Good morning and thanks for watching Market Day Report. I'm Christina Loren. Farmers and ranchers often think ahead to prepare to pass their operation along after death. But what are the stipulations when it comes to writing their own will? Although it can be done, Ag Professor of Law Roger McEowen says it probably isn't the best idea. He now joins us by phone to discuss imprecise language in wills and the problems that can be created. Thanks so much for joining us, Roger. And let's start with how we can create language, how it can be unclear when writing a will, and the issues that might come up as a result.
Sure. Good morning, Christina. Some words do have multiple meanings in different contexts, and that's really the crux of the problem. And of course, other words might simply be imprecise and not really require the specific action that the individual decedent that prepared the will or had the will prepared for them thought. So this is a big problem, a potential problem when a person drafts their own will, which is permissible, and it can even be a problem when a professional drafts the will, too. We have to be very, very careful to make sure that we say what we mean and we mean what we say when we draft wills and trusts.
Absolutely. Let's talk about an example of this and how people may go wrong.
Well, there was a recent Texas Court of Appeals case that really illustrates this, and it involved an individual that owned ranch land, and he left a will and a trust. The trust was created by the will. The ranch land ends up in the trust, and it said my trustee, which is one of his kids, can sell the corpus of the trust, which was the ranch land, but he said also it is my desire that my ranch stay intact as long as is reasonable. And it also said in another pertinent portion that the four beneficiaries of his estate, which were his children, if they wanted to sell their portion of the ranch, they could only sell it to the remaining beneficiaries. So his idea was what he was trying to do, and this was professionally drafted. I think the idea there was clear. He wanted the ranch to stay in the family, but the precise language allowed the trustee to sell the ranch land. The imprecise language said it's my desire that it stay intact as long as reasonable, and the court said we're not going to pay any attention to that imprecise, what's called precatory language. We will uphold the trustee's power to sell the ranch. The trustee sold it to a third party outside the family, and it was gone.
Wow, that is a tough case there. Now, do you have any advice for farmers going forward? And especially, we want to talk about how important the signature is as well. You have to have that will or trust signed, right?
Yeah, it has to be signed, and the state laws will require that signature to be witnessed. Now, that requirement may be dropped if it's what we call a holographic will that's written by the individual themselves. But each state has specific requirements that must be satisfied for a will to be valid. And I would just go back to sum up to say, if you're trying to do this on your own, be very careful. Even mistakes can be made when wills and trusts are professionally drafted. But again, say what you mean, be very precise, mean what you say. Don't use language that says it's my wish, it's my desire. Courts won't uphold that.
Okay, you can visit washburnlaw.edu/WALTR for more information. Roger McEowen, we really appreciate you joining us from the Washburn University School of Law in Topeka, Kansas.